has been murdered. Now, in wake of all this, tell me, is it possible or is it not true that there, in reality today, RTI Act has become an orphan child, abandoned by the government and forgotten by the activists who actually got it enacted? Why is all this happening? I think we all know the answer in our hearts. Like all of us, the government and the bureaucrats wish to consolidate their jagirs and let no one know that what the state of affairs is. The European equivalent of fiefdom and fiefs is what appears to be the reality. The orphan child thus needs a caring family to protect it and to cherish it, to aid its growth so that it can effectively help the community as a whole. Thus it requires strengthening, dear friends. Now let me offer you 4 suggestions which according to me will strengthen the Act. Number 1, professionalism at the CIC level is a must. Meaning, starting from the appointment of the Chief Information Commissioner and the support staff should be done professionally. Number 2, public consultations and studies before any rules are changed or any move to amend the Act is made. Next, to aid in its expansion so that poorest of poor who is suffering any kind of injustice of corruption can at least voice his problem and look for answers. To protect the applicants from retribution of all forms. Dear friends, according to me, these are 4 solutions which I am offering which will further strengthen the Act. Now coming lastly to the PPP. Let me inform you, you already know it very well, that Section 4 is a section which lists about 17 clauses, and these are obligations to all public authorities and they have to put all that information on record. Now what is happening is that today there is a concerted effort by the government that private bodies which are now combining themselves to form and do business with the government, they are claiming that they are not public authorities under the Act, and this is an issue which is a burning issue and is at the moment needs to be addressed. As far as there's one more information which I need to give you, that CIC had brought the private power distribution companies in Delhi, the electricity power distribution companies and the National Stock Exchange under purview of the Act. Now this order of the CIC has been stayed by the Delhi High Court. Dear friends, in the end I just conclude by saying that if since 2005 till today, the struggle which the Act has faced in its operation is something which will have to end, and that can end only with the cooperation of the people with the activists who are facing all the wrong. Thank you very much for giving me this opportunity to address you. Thank you.
Now I request Mr. J. He was a Vice President of Advocates Association of Western India, Member of Bar Council of Maharashtra, and as I already said, Secretary, TheBarAssociation of India, Maharashtra. A very popular bar leader.
Namaskar. Being a second batsman, I have 2 duties. Now we have seen it's a season of IPL, Indian Premier League. So 20 overs matches. As a result of that, there are some restrictions. There are 4 batsmen. The first batsman has consumed substantial time and he has made a good beginning. As a result of that, the second batsman is having a limitation. What is that limitation? Now I will not touch all those aspects which have been covered by the first speaker, and I will leave few topics for the other 2 batsmen. All these speakers are having some commitment and they are having some better understanding. And now therefore let us go step by step. Now the simple thing, Our first speaker has informed us what is the scheme, how this worked, when it started, all these things are there. I am going to ask you a simple question and let us try to find out what is the answer. My simple question, whether RTI is a mean or RTI is a goal. Once we find the answer to this question, I am sure we will be able to find out the real answer for this topic. The topic is very simple. Does it require dilution or further strengthening? And for finding the answer to this topic, the simple test is whether RTI is a mean or RTI is a goal. If we come to the conclusion that RTI is a mean, then obviously further strengthening will be required. And if we come to the other conclusion, that is RTI is a goal to be achieved, then obviously no further strengthening is required, because the law is there already in the field. No doubt, we are a student of law and we are dealing with the rule of law. So therefore from 2005 till 2012, 7 years means just a child law. It is still in the child phase, maybe in the nursery, KG or something. So therefore law will take its own time, but once we come to the conclusion that RTI is a goal, then the law is already in the field. No doubt, today, tomorrow, whenever the time permits and whenever our targets are achieved, we can come to the conclusion that yes, RTI goal is achieved. Now therefore, to find out whether it is a mean or whether it is a goal, we will have to find out what is the object behind this act. And then therefore, the reference to the preamble of this act will be relevant. I know some of us are the law students who are still completing their graduation. So therefore, I am going to request them, please open the statute book whenever you will get a time, and few keywords are there, and with the basis of that keyword, I am going to proceed further. What are those keywords? The practical regime, inverted comma, practical regime, what was intended, the democratic principles, that's another keyword. You will find transparency is the another keyword why the RTI Act has been introduced, accountability, and ultimately to eradicate the corruption. Now if we conclude all these few words and try to find out a better rather answer to our question, then one can say that these are the targets, these are the ultimate goals which are required to be achieved. So therefore now the simple question, merely by enacting the law can we say that the goal has been achieved? Obviously no. And now therefore let us go further and find out what has happened in last 7 years. I come from Maharashtra and I am very proud to inform all our good friends who are sitting here that so far as Maharashtra is concerned, prior to 2005, we were having our own act, that is the Maharashtra Right to Information Act 2002. Something interesting. You must be aware about the word Ordinance Raj. Means ordinance after ordinances, because the legislators won't get time or they are opposing converting that particular ordinance into a bill by having a discussion, debate or whatever best possible method. Maharashtra was not an example, not an exception, and in Maharashtra also the first ordinance lapsed because the legislators were opposing this concept. Second ordinance came and at the end of the second ordinance ultimately the act was converted into the bill was converted into an act. I can also say and inform all our good friends who are sitting here that Maharashtra was the fourth state in the entire India which enacted this law. Goa was the first, 1997, Karnataka 2000, Rajasthan 2000, Delhi was 2001. These are the 3-4 states which were there. Maharashtra is there, MP is there, Jammu and Kashmir is also having a different act. Now the simple questions, in last so many years, so far as Maharashtra is concerned, about 10 years is the period when we have tested this act. And I as an advocate, I have appeared for various RTI activists. Now obviously I appeared in the sense I practiced in the High Court, so therefore I appeared on their behalf before the Honorable High Court at Mumbai. Maybe by way of filing a writ petition or maybe by way of filing of a public interest litigation. What are the problems which are faced by those persons in implementation of this act? And now therefore let me point out, they are simply saying that sir, new act has come into effect but there is no mechanism which is provided for execution of the orders. I'll go one step ahead, take a case that we are all Kaurava and Pandavas and there is a degree of partition among us. Then what is the remedy? We will have to go to the civil court and go for execution. Give me a execution, give me my independent, different, distinct share. Take a case that there is some order which is passed by the first appellate authority. Is there any mechanism which is provided under the Act for implementation of that order? Unfortunately, there is no provision. As well as along with Mr. Gandhi also. So therefore, I have a better knowledge about this Act. The statistic shows 22,000 appeals were pending before the State Information Commission till November 2011 in Maharashtra. Now this is the statistic which goes to show that for another few years it is virtually impossible to conclude hearing of those cases. So merely creating a statute and creating a right in favor of the citizen, the problem will not be solved. Let us go further. What is their grievance? Their grievance is, sir, nowadays some innovative methods have been introduced. What are those innovative methods? They are unable to wipe out that pregnancy. Therefore, the information commissioners are introducing Lok Adalat in RTI. Very strange, very surprising. How can there be a Lok Adalat in an RTI? Basically, they are saying that look at this is a PIO. You want something, he wants something. All right, forget about your 100% demand. He is giving you 5 or 10%. Accept it, and you may renew your application. We want disposal of the cases. Where we are going? Now, therefore, those activist friends are saying that, sir, the Act is there, no difficulty. Act is having a very good object, very good goal to be achieved. The practical reality is something else. In Maharashtra, we have various divisions. Even today, 3 CIC commissioners, the posting have not been made. Those posts are still lying vacant. Namely, the post for so far as Mumbai region, Konkan region and Pune region, these are the 3 commissioners whose posts are lying vacant. I do not know what is the experience of rest of India, but I am sure the experience will be the same quality, same situation will be there. Now this is one with reference to the infrastructure, with reference to the posting, with reference to the implementing machinery. I am asking a simple question to all of us. Now we are aware what is the penalty so far as this Act is concerned. Section 20 contemplates rupees 250 per day is the penalty, and there is a cap. It says that not more than 25,000. There are some persons who are coming in front of us and they are saying that, sir, don't you think that 250 is grossly inadequate? He is giving an example. I am not adding anything. The person is giving an example, sir, I am asking the tender documents. I am asking some important decisions taken by the authority, and that contractor is interested in concealing that information. So therefore he will go on paying rupees 250 plus something over and above that to that Babu who is supposed to give that information. 250, whether it carries any meaning in the eyes of law per day? Obviously the answer will be no. So therefore if you want a proper and effective implementation, then there has to be some kind of deterrent effect if the person commits a default. Let us go back to the jurisprudence. Theories of punishment, we are aware about it. Can you say that because of this 250 rupees per day, there is some kind of deterrentness in the mind of the PIO? Obviously, that 250 have lost its significance. Even a person who is working as a Babu or Chaprasi, he gets a substantial sum of the amount as a salary after 6 pay commission. So therefore, according to me, the objection which have been raised by those persons is again correct. The law is not having sufficient deterrence. One of the important topic is nowadays in Maharashtra we are experiencing, and the rest of the India also, few examples which have been cited by Rajiv Datta, the earlier speaker. There are examples in Bhopal, the attack took place. Not only that, in Maharashtra the person lost his life. Who was he? In between Bombay to Pune there is a place by name Lonavala. You might have heard this name, Lonavala, Khandala. These are the hill station. Near Lonavala, there is a Talegaon, another Tahsil place. A activist from Tahsil place, he started making a follow-up of that highway which has been made between Bombay to Pune, that is express highway. And when he started making a follow-up, at that point of time, unfortunately, that gentleman, Mr. Shetty, was required to lose his life. The case was not registered by the authorities. No investigation took place. He died in January 2010. Matter was filed in the Honorable Bombay High Court. Ultimately, in the month of May 2010, Division Bench of Bombay High Court was required to pass an order, give protection, police protection to the families of those persons. This is the actual reality. There are cases of attacks. Not only that killing, not only murder, the attack. Not only that, there are cases of harassment, there are cases of the threat which has been given to those activists. Where is the machinery for protecting the interest of those persons? Ultimately, if we come to the conclusion that the act is having some good goal to be achieved, then the act is not having any machinery for protecting the interest of those persons who are going to implement the act. Take a case of any legislation. You will find in the legislation there will be somebody who is supposed to implement. Take a case of a CRPC, IPC or any criminal statute. You will find there will be an investigating officer. There will be a person who can implement the provisions of the act. In this act, if the person, the citizen is going to make an application, don't you think that person needs some kind of further protection? In the parliament, this issue was raised. The minister replied in the parliament saying that in India, the Indian Penal Code and Criminal Procedure Code are enough powerful to protect those RTI activists. There is no need for a separate provision for protecting the interest of those persons. Now therefore question comes, if we are going to strengthen, if we come to the conclusion that the act requires further strengthening, then automatically there is a need for protecting those persons who are the RTI activists. Now let us proceed further. What is happening actually, once the act has been enacted, some kind of further amendment in the corresponding statutes are required. What are those statutes? Let us go to the Evidence Act. And all my good friends are here, to the student who are student of law. Let us go back to our offices, let us go back to our library. Let us open Indian Evidence Act section 123, 124 and 162. In my respectful submission, these are the acts which are still continuing those provisions. How to conceal the information? Now, don't you think that if the act requires further strengthening, then the corresponding amendment in that act is required? Civil Services Act 1965 it was enacted. Even today that casts a duty that the civil servant should not disclose the information to any other person unless by special or general order he has been permitted to do so. On the one hand, there is a Right to Information Act. On the other hand, second, the CCS, Central Civil Service Act. Now what does this show? This shows that there is a further reconciliation which is required. That merely enacting of an act is not going to help the Indian democracy. Likewise, we will find atomic energy. Likewise, we will find there are various other acts which are in the need of the further amendment. Now the simple question comes. This act is creating two things. One, creates a right in favor of the public and corresponding duty in favor of the respective authorities. Now the act contemplates that the authorities are supposed to publish the report. Section 25 contemplates obligation of the CIC and SIC to publish their periodical reports. The reports are coming. Few reports are coming. Those are again stereotype reports. That creates another question whether furthermore some provisions are required to be made. Now all these things are there. Ultimately the persons who are activists who are using this particular power are the whistleblowers. Now so far as Whistleblower Protection Act is concerned, still it is lying in the our parliament. Now the latest situation is this, that particular act has been introduced in Rajya Sabha and it was introduced on 29th of March 2012, last week, and it is still pending. Lok Sabha has already passed that particular bill on 28th of December 2011. The corresponding protection to the RTI activists which I was referring is the same thing. Let me conclude because there are two more batsmen who are yet to come and we all are eager to see their whatever fantastic sharing of their thoughts. Ultimately, it's a simple question which was asked. Does it require dilution or further strengthening? I am sure every speaker, not only every speaker, but all of us will come to the conclusion that the further strengthening of this act is required. RTI is a mean to achieve the rule of law. And if we are intending to have a rule of law in our India, then automatically further strengthening of this Right to Information Act will be required. Thanks a lot. Dhanyavad.
Thank you. Very forceful presentation and pointing out the deficiencies there. Now we are in a better position to appreciate the deficiencies and the practical difficulties of listening to Mr. Anil and Mr. J. Now I request Mr. Vipul Maheshwari, the Secretary, TheBarAssociation of India, Uttar Pradesh, to make his presentation in about 15 minutes.
Good afternoon. This seminar has been kept to discuss the law governing the right to information. I am extremely thankful to all the speakers and the delegates who are present here to discuss this issue. I extend my sincere thanks to Mr. Anil B, Mr. B. Rao, Mr. Ashok Desai, Mr. Bhat for their constant support and encouragement in conducting this convention. I am indeed very happy to have the privilege of interacting with distinguished delegates coming from different parts of the country to attend this convention. I'll be, as my previous speakers has talked about the practical difficulties, I'll be touching upon the different countries, how it has been enacted and how, even 200 years back this has started in Sweden and different countries, how it has adopted this and then it came to India in 2005. Right to information is one of the great topics to be discussed on this platform. I will start with the Sanskrit shloka. Yada yada hi dharmasya glanit bhavati bharate abhyutthanam adharmasya tadatmanam srajanyam. जब जब धरती पे पाप पड़ेगा, जब जब लोग अधर्म के रास्ते पर चलेंगे, तब तब भगवान श्री कृष्ण will come in this world or incarnate himself to save this world, to save the priest, to destroy the evil. Friends, today the Right to Information Act can be compared to Lord Shri Krishna's role in Mahabharata. As Shri Krishna had played a vital role in ending the adharma in Mahabharata, the same can be attributed to Right to Information Act, playing the vital role in bringing the transparency and bringing the corrupt official to books. The RTI Act has made a positive impact on the lives of people like no other act has done before. More and more people are filing